For the reasons explained below, I recommend that Backdoor Dugan's motion to dismiss be denied. After the defense attorney failed to appear, the judge ordered law enforcement to forcibly and with excessive force seize and bring the attorney to the courtroom. Wild. Never seen that happen.
There's no amnesty. What we're doing is we're getting rid of criminals, but we are doing a work program.
Judge Dugan loses a big one. This is the judge who escaped that illegal alien out the back door of her courtroom and was colluding with the defense attorney to ignore the prosecutor and the victims who were in the courtroom as they were skedaddling this dude right out the back. Now, she submitted a motion to dismiss her case, and we read through some of that here where she explained, I'm a judge, I have immunity, I can do whatever I want. And I was operating my courtroom. I can allow people in, I can exit people out, I can maintain the population, and so I am immune for this. And she basically used the 3-bucket framework that we talked about during the Trump immunity saga and said, I am in the final bucket. I have total immunity. I cannot be prosecuted. So that went up and now it has come back down. And the judge issued this ruling out of Wisconsin, writing, all right, judge, on May 13th, a grand jury indicted Backdoor Judge Dugan. Count 1, knowingly concealing a person on illegal for who's had a valid arrest warrant issued. And count 2, obstruction of homeland security. She was arraigned. She got entered a plea of not guilty. A jury trial is going to be scheduled soon. Now, Dugan, the judge, she moved to dismiss the case. She said, well, I'm a judge. I'm immune from criminal prosecution. And that this prosecution also violates the federal power under the 10th Amendment that says that any powers that are not enumerated are reserved to the states. And so basically the feds can't encroach on state business. And that the indictment could be dismissed also under the canon of constitutional avoidance, right? So 3 main claims. 1, I'm immune. Number 2, 10th Amendment. And number 3, constitutional avoidance, right? Which is this idea that we're on the same side. Like we're both working for the government. We had a little bit of a disagreement here, but we shouldn't enter into this litigation, in this case, criminal prosecution, because it's going to create a breakdown in our constitutional order. Now, the government, Trump's DOJ, opposes the judge's motion and objects to the filing of any of these amicus briefs on her behalf. And here is what the judge says. For the reasons explained below, I recommend that Backdoor Dugan's motion to dismiss be denied. Get out. Further, the parties' request for leave to file amicus briefs are granted. So you can file some additional paperwork. We'll read it. Now, here's what the indictment said. Backdoor Dugan tried to escape this illegal alien out the back door. He had a warrant. Count 2, she tried to obstruct and impede the enforcement of the law. And she did these things. The judge is reminding us this is what they articulated. Dugan confronted members of ICE and falsely told them they needed a judicial warrant to effectuate the arrest of this illegal who beat the crap out of several people who were in the courtroom, allegedly. So then she goes up and runs interference. Upon learning that the ICE agent said, well, we got an administrative warrant. She said, you all need to follow me and you should leave the location of this planned arrest and you should come with me to the chief judge's office so that they could then remove the illegals from the presence. She then also took the case off the record, right? The victims were there. The prosecutor was there. She basically called the case and continued it without notifying them at all. Ex parte actions. The prosecutor sitting there like, I got victims in the courtroom. They're sitting here. Case got bumped. She also directed the illegal and his lawyer to exit the courtroom through a non-public jury door, use her back door, just willy-nilly. Advised that the counsel and the EFR could also then appear by Zoom for his next court date, right? So other defendants have to show up in court. But if you're an illegal alien, not only does the FBI allow you to traffic kids in your floorboards, not only can you drive around without licenses, registration, insurance, any of those things, Tennessee State Highway Patrol just lets you go, whatever. But when you actually beat other people and they show up in court, victims want to be there to make sure that there is justice happening. The judge reschedules it for Zoom. What a just lady. All for illegals. They get due process premium version. We're just on like standard American due process, like for citizens. We don't get it at all. But illegals, they get due process premium. They get like 3 trials before you can deport them, according to the ACLU. So here's what the judge says. Now, the rules say that a party may raise a motion to dismiss, and if they're going to raise that motion to dismiss, then the court is going to assume that the facts and the allegations in the indictment are true. Okay, so we're like not going to battle about that. We're going to say Trump's allegations are true, and we must view this in all the light most favorable to the government, right? The non-moving party is going to get the benefit of the doubt now. So Dugan says, dismiss this case I'm immune. They're going to say, well, okay, now we're just going to say if everything in the government's indictment is true and you still win, then we will dismiss the case. But if it's not, or there's an argument about it, then the case will proceed forward. Dugan now moves to dismiss the indictment on 3 grounds. 1, immune, barred by judicial immunity. 2, 10th Amendment. 3, judicial canons. He's going to go through them one by one. Now, the parties differ on their view of the law. And so let's talk about judicial immunity. Does it apply to Dugan or not? Says there's a long concept here, writing judicial immunity goes back 400 years to English common law. Prior to the creation of the right to appeal, a losing litigant would seek nullification of a false judgment and a fine against the judge who rendered it. So people would like sue the judge. Then they gave an appeal system and they said, all right, don't sue the judge. If you think the judge gave you a bad ruling, that's not the proper thing. Just appeal it. And then the common law changed. And we're like, okay, appeals is better than just suing the judges. Now, the seminal case was done by Lord Coke in 1607. And this was the question about whether the judge, who back then was presiding over a murder trial in England, Floyd versus Barker, whether he could be prosecuted in another court for criminal conspiracy. They said, oh, he was involved in the murders. Now, Lord Coke concluded the judges were immune from these prosecutions, stating, a judge for anything done by him as a judge is the authority which the king hath committed to him, and you shall not be drawn before another judge. In other words, Lord Coke said there's absolute immunity for all judicial acts. Now, that case is important for articulating the first time what are now considered some of the modern policies of judicial immunity. Why do we want it? Well, because it might help ensure the finality of judgments. It protects judicial independence. It avoids continual attacks upon judges who are just being sincere. It protects the system of justice from falling into disrepute and more. So then that was in England. Then in 1868, it started to get applied to the United States. Started in this case called Randall versus Brigham. In Randall, an attorney was accused of obtaining an agreement from a client that was unconscionable and extortionate of that client and grossly unprofessional, and he was removed. He sued the judge, said, you can't remove me as a lawyer, back in 1868, and he sued the judge. And it is a general principle that they're not liable if they were acting within their jurisdiction. Now, there is an exception to absolute immunity where the judge is acting maliciously or corruptly. 3 years later, there was another decision. Then we get to the modern era. We got U.S. Code 42, 1983. Someone sued. Supreme Court said, is a local judge liable for damages being sued under this provision of the law? Section 1983 allows people to sue state actors for depriving them of their constitutional rights. You see a lot of these types of claims. Section 1983 claims come up all the time. In this case, back in 1967, the plaintiffs were a group of white and African-American Episcopalians who attempted to use segregated facilities at a bus terminal. They sued the local cops and the municipal police justice for false imprisonment, and they said the judge findings of guilt were based on discrimination. Now, the court had no difficulty in finding the judge was immune from damages in that case. They said immunity applies even when the judge is accused of acting maliciously or corruptly, because that's going to happen a lot. Then a decade later, Supreme Court had another case in 1980, and judges went to trial in this one. Then in 1988, question came up in front of the Supreme Court. The court again was tasked with determining what is a judicial act that relates to immunity. Can a judge using her back door be a judicial act that is protected? Under Illinois law, a circuit judge has the authority to hire adult probation officers, 1988 case, who were removable at his discretion. Now, Judge White hired this woman called Cynthia as an adult officer, then demoted Forrester and terminated her. She said that's sex discrimination, and she sued. A jury granted an award. Judge moved for a new trial and moved for summary judgment. Says, you can't sue me, I demoted you. Both the district court and the court of appeals said Judge White was immune from damages. But the Supreme Court reversed it, right? So that judge was liable, the Supreme Court says. In doing so, it noted that running through our cases with fair consistency, in which the court examines the nature of these acts, the court said that difficulties have arisen. What is the line between truly judicial acts that deserve immunity and acts that simply have been done by a judge in her courtroom? Like, could the judge just shoot somebody in the head in her courtroom and just say, well, that's the sentence I wanted. Now you're dead. I have total immunity from that because it was the appropriate sentence under the law, I think. Or does she have to follow the law and impose lawful sentences, right? And kind of follow the rules. So if there's another co-equal branch, so-called, of government that has an administrative warrant and has the right to be outside the courtroom to arrest an individual, not interfering with your business at all, just waiting outside. Nobody even knew they were there until someone teed them off from security. So can she do that too? Can she just do whatever she wants? The court reiterated that immunity is justified and defined by the functions it serves and protects, not by the person to whom it attaches. Just because the judge was wearing a robe and in her courtroom doesn't mean she can do whatever she wants. What is the function of doing everything she did? Is that in the interest of justice, or is that in the interest of that illegal alien? Also noted that the court has never undertaken to articulate a precise and general definition of the acts that are entitled to immunity. The court found that the cases say that there's a pretty intelligible distinction between administrative, legislative, executive functions, and more. And so the court found that judicial immunity did not apply to acts like promulgating a code of conduct for attorneys or like firing your staff member. That's like not a judicial function, demoting your staff, which is not an act of adjudication. It concluded that Judge White was acting in an administrative capacity when he demoted and discharged that woman. And so, since he is doing that in administrative function, he is not entitled to absolute immunity for that decision, and he was allowed to be sued. 3 years later, 1991, court again came in. In this case, the person suing was a public defender, was scheduled to appear before a judge. After the defense attorney failed to appear, the judge ordered law enforcement to forcibly and with excessive force seize and bring the attorney to the courtroom. Wild. Never seen that happen. To bring the defense attorney in with excessive force, seize him and drag him to my courtroom, who's a public defender? Crazy. The court stated the case law makes clear that immunity is overcome in only two sets of circumstances: actions not taken in the judge's judicial capacity and actions taken in complete absence of all jurisdiction. Right now, as to the first circumstance, in determining whether an act falls within the judge's capacity, the court clarified that the relevant inquiry must be the nation and function of the act rather than the act itself. In other words, one must look to the act's relation to the general function normally performed by a judge, right? So the judge would say, well, I hold hearings and I have a hearing here and this attorney's not here and he's scheduled to be here. In this case, the judge's discretion to the court officers to bring a person who is in the courthouse before him is a function normally performed by a judge, right? Happens all the time. You're ordered to be here. Here's a subpoena. Be in my courtroom by this time or else. However, a judge's direction to carry out a judicial order with excessive force is not. So you can't shoot somebody in the head in your courtroom. The court said, however, that it cannot scrutinize only the particular act in question because any mistake of a judge in excess of his authority would become non-judicial, as no improper act is normally performed by a judge, right? Judges, by virtue of their definition, don't do improper things. The court further explained that because judicial immunity is immunity from the lawsuit and not just from damages, judicial immunity is not overcome by allegations of bad faith or malice, which ordinarily cannot be resolved without discovery and trial. As to the second circumstance, which is you have no jurisdiction, the court concluded that if the judge authorized and ratified the use of excessive force, if he said, yep, go drag him in here, he acted in excess of his authority. You can't do that. However, such an action taken in the very aid of the judge's jurisdiction over a matter before him cannot be said to have taken in the absence of jurisdiction. And so thus the court found the judge was immune. So I guess he could drag him in. So now that was allowed, but that was in the jurisdiction of the court. So let's see. Now in some, the doctrine that a judge enjoys absolute immunity is solidly established. There is a lot of immunity, but judicial immunity is not a bar to prospective injunctive relief, nor does it bar an award of attorney's fees. This is not civil, and Dugan has been charged under federal statutes. And so the question is whether the clearly established principles in civil lawsuits against judges apply to criminal prosecutions of judges as well. Now, as discussed, the England case with Floyd was a criminal case. And so this goes all the way back to Floyd. We also had 2 Civil War cases, and the most we have gleaned from the Supreme Court about judicial immunity when it comes to criminal cases have been in reference to Section 242, which is not charged. And the analog, Section 1983, is also not here. This criminal statute in 1983 was passed back in 1866, and although the language of the statute itself does not address judges, it does talk about state actors, and of course judges would be state actors in some instances. In this case, Dugan was. Now, upon reconsidering the bill, the Senator Lyman Trumbull responded that a judge, if he acts corruptly or viciously in the execution or under the color of law, may be and ought to be punished, but if he acted innocently, he would not be punished. And so the Supreme Court came down with some more cases. 100 years later, the court invoked the threat of judicial prosecution for corrupt judges, but in some, although the 17th century case of Floyd declared judges immune from criminal prosecution, the Supreme Court has only cited Floyd in civil cases, and the only context, this judge says, in which the Supreme Court has spoken on judicial immunity from criminal prosecution, the court found that judges are not immune from criminal prosecution under the statute. So Dugan not looking good. Now Dugan says that English law, these are her arguments, and common law begins with absolute judicial immunity. There's only a couple things that can break my immunity. She says there's only 3 exceptions that allow you to charge me if I've done one of these things, but I haven't. She says a judge can only be prosecuted if it's wholly unofficial. She says that a judge can only be prosecuted for criminal deprivation of a constitutional right, so not obstruction. You can only charge her with one type of crime. And third, judges can be prosecuted if she conducts an official act, but the act is coupled with an ordinary crime only for self-enrichment or self-gratification, which of course I think she was highly gratified when she let that illegal use her back door, because it is an attack on Trump, right? She was sticking it to Trump by letting him out. I'm unconvinced that any of these cases that Dugan has cited here establish any settled law on judicial immunity as applied to criminal prosecutions. They exist in civil context, but not here. Now, she also says that you can only charge me with one type of crime. A lot of that goes back to Floyd, but I am unconvinced that the absence of judicial immunity for violations of that section means that judges are immune for other criminal statutes, right? All other criminal statutes, you can only be prosecuted for this one and nothing else? She says yes. Now, again, Dugan asserts that there are only 3 categories for where she can be prosecuted. Now, wholly unofficial acts does not merit discussion. The parties don't dispute that judges are not immune for wholly unofficial acts, right? If Dugan shoots somebody at a Circle K, she'll get prosecuted for that. Dugan's second category, though, criminal deprivation of constitutional rights, is discussed above, and she's not charged with that. And here's another example. Her third category of cases, remember this kids for cash scheme where this judge was siphoning off kids for money? The third category of cases where judges are prosecuted for actions when they get kickbacks. Dugan argues that these cases are distinguishable from other crimes for immunity purposes because they're self-satisfying. She says that she was acting selflessly with no hint of self-dealing. She enjoyed that whole little event, okay? She got in trouble immediately, but she was going to text her friends and tell them she's part of the resistance. But whether a judge seeks his own self-gratification like she did with the back door, and self-enrichment is not a distinguishing feature for immunity. Here's another example. Kids for cash. 2 Pennsylvania scumbag judges called Michael Conahan and Mark Ciavarella, they accepted kickbacks. They sent juveniles to private detention centers and got paid for it. The judges were alleged to have used their influence as judicial officers to select this one location as detention facilities, and they got a bunch of money, $2.6 million for their influence. Can they do that? Conahan was alleged to have done, amongst other things, remove funding, sign a secret placement guarantee that they'd be sending them over there, prevent audits, and more. He was alleged to have sentenced thousands of juveniles in violation of their constitutional rights and sending them off there. They were sued. The court, considering the Supreme Court's jurisprudence, found the judges have absolute immunity for their role as judicial officers. The court said that judicial immunity applies if a judge has jurisdiction over the dispute, conducted a judicial act, as opposed to some sort of administrative, executive, or legislative one. Now, the people who sued said, wait a minute, these judges can just sentence us and get paid millions? They said that because the judges' decisions were made corruptly or in a predetermined fashion, they were not just judicial acts. Like, you can't just say, this is a judicial act, I'm a judge, and so I can do corrupt things. The court disagreed, stating, for example, that the allegation that Conahan had a corrupt motive for issuing the injunction was no different than the allegations in another judge. The Supreme Court found that there was judicial immunity. The court stated that this judge's determinations of delinquency were judicial acts, and the fact that they were made corruptly or with malice was irrelevant. Now, however, to the extent the judge's actions were not judicial in nature, such as the signing of the placement agreement or the budget request, judicial immunity did not shield this conduct, all right? So they basically split hairs on it. The court acknowledged that because of judicial immunity, he would escape civil liability for the vast majority of his conduct. The court also stated that judges were still subject to criminal prosecution, though, noting that judges here have been indicted by a federal grand jury for the conduct which damages are sought in this case. They were indeed indicted under racketeering laws, right, but not for the judicial crimes. Now, what the Kids for Cash case shows, says this judge, is that while judges may be civilly immune for judicial acts, it does not follow that they're also criminally immune for wholly judicial acts, right? Like, they got prosecuted. Recall, the court found that the determinations of delinquencies and sentences were judicial acts, and while judicial immunity shielded him from civil liability, he was criminally prosecuted for those same things. Now, Dugan cites to another case, calls it a close call, but the court rejected those arguments there. Dugan also cites Claiborne, another case, but while many of these cases involve crimes where the motivation was financial gain, it doesn't mean that you have to have financial gain before you can get prosecuted. And then Dugan relies on the Trump case. Remember, she's citing the Supreme Court, says, finally, Dugan cites the SCOTUS, where the court said that Trump does have absolute immunity when he's being prosecuted for his constitutional powers. Now, while acknowledging that Trump was talking about this as the president, she says, well, it also applies to me, the same buckets. The judge says, in Trump, like here, the parties don't dispute that criminal immunity does not apply to unofficial acts. Trump never said that. But as to official acts, yeah, you're immune. If it's within the outer perimeter, you're allowed to do the things. Trump argued that given the court's pronouncement about civil immunity, he's absolutely immune as well. Now, the court agreed, said the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. And if those official acts implicate the core constitutional powers, those count. Or if they're within the outer perimeter, there's at least a presumptive immunity. We talked about those three buckets many times. Now, the court reiterated the president is not above the law. He is charged with enforcing the law, but he's not above them. And the court also found that it had to balance the competing interests. Dugan says, all that same applies to me. But the judge says, perhaps in some future case, the Supreme Court will expand this to judges. But at this time, I'm unconvinced that either the common law or the Trump decision provide the authority for applying the civil immunity to criminal prosecutions of you, Dugan. So in summary, having reviewed all of this, it is well established in the civil context that judges have absolute immunity from civil damages from judicial acts. While it's not always crystal clear what a judicial act is, like using your back door or not, the Supreme Court counsels courts to consider whether the act is a function normally performed by a judge. No, using the back door and continuing a case to avoid an arrest by federal agents, that's not an act normally performed by the judge. The court has stated there is an intelligible distinction between judicial acts and other functions, and so in the criminal context, the case law supports charges. Judges are not immune from prosecution for the criminal deprivation of constitutional rights. Other judges can be convicted of murdering your wife as they watch television at home, and a state court judge was convicted of sexual battery of a female lawyer in his chambers. Can you just abuse women because you're in your chambers and you're wearing a robe? And third, judges are not shielded from immunity that are violations of criminal law. And so if we apply all of that, which was a very nice summary, the question, does judicial immunity shield Dugan from prosecution? The answer is no. As discussed above, there is no firmly established absolute judicial immunity barring criminal prosecution of judges for judicial acts. Other than the 17th century case in England, the United States Supreme Court has only applied the concept of immunity for judges in civil cases. Even before the lower courts, with the exception of a single case, the cases Dugan cites don't help. Further, the category of cases where judges were prosecuted also answers this question in the negative. That means that Dugan does not have immunity. The Kids for Cash scheme was indisputably within the scope of the judge's duties, but the court found that the judge was immune from that, but they were still prosecuted criminally because their criminal conduct did not shield them from prosecution. Now, she tries to distinguish her case by saying, I didn't get any gratification. I had no self-gratification when I let that illegal use my back door. I didn't enjoy it at all. We know she did. Again, the distinction takes these official duty cases out of this motive. Like, we don't care about your motive. We care about whether a criminal law has been violated. And furthermore, the only case with similar allegations to this case is called United States versus Joseph. There was a Massachusetts district court judge, Judge Shelley Richmond Joseph, and she was charged here. Obstruction of justice, obstruction of a federal proceeding. In that case, an ICE officer working with Homeland arrived at the courthouse. Wow, we have a similar case in 2020. To take into custody an individual who had been arrested days earlier and was the subject of a detainer. Homeland intended to detain that individual and remove him. The judge allegedly facilitated the departure from the courthouse using her back door, the rear Sally port door, used her rear entry to let him escape. Joseph moved to dismiss the judge of the indictment on judicial immunity grounds, the party's hotly contested immunity. District court declined to resolve that question. The indictment says that she acted corruptly, and just like here, they say Dugan acted corruptly. Now, and as the Joseph court found, to the extent immunity arises or in the criminal context, it does not shield against corruption. And so this judge says, in my view, this is consistent with the cases where judges were prosecuted for performing official acts intertwined with bribery and other things, and judicial immunity does not bar prosecution. Now, I agree with Dugan, says this judge, that judges do play many roles. She must interpret the law, apply the law. She must also ensure the efficient running of her courtroom. And so I agree that in determining whether a warrant establishes probable cause, directing outside people, addressing a case off the record, telling people in her courtroom what door to use, and allowing a party to appear by Zoom are all a part of a judge's job ordinarily. I also agree with Dugan that former judges in appellate courts are the proper forum to address disagreements with judges. However, I do not agree that the case law says that these judicial acts bar prosecution where the indictment says you did all of those things corruptly to facilitate a violation of the law. Now, at bottom, the indictment does not charge Dugan for opining on the fly. She's not charged for managing her courtroom. She's not charged with allowing somebody to appear by Zoom. And so she's not immune from those things, or she's not charged for those things. The indictment says she violated criminal law. She knowingly concealed an illegal. He had a valid arrest warrant, knew about the arrest warrant, and then corruptly impeded them from arresting him. Now, this conclusion does not leave judges acting in their official capacity at the mercy of prosecutors. There's still plenty of protections here. And so I recommend, this judge says, that Dugan's motion to dismiss the indictment based on judicial immunity be denied. denied. Now, Dugan next says the 10th Amendment says, you can't prosecute me because states' rights. Says, well, the same is true here. Dugan violated federal crimes. Whether she violated these statutes, she was not performing her duties in their federal charges. And so I recommend that the dismissal on this basis also be denied. And finally, Dugan invokes the canon of constitutional avoidance. This is the idea that if stuff is ambiguous, then you shouldn't use it, especially if it's going to cause a big problem between the branches. She says this is ambiguous, and so you should just give me the benefit of the doubt. But I think this judge says her motion to dismiss should be denied. Now, in litigating this, the parties contest the facts, and this counsels against dismissal. So we're going to need to allow this to develop, and the amicus briefs can be filed. This judge, in summation, writes, it is well established and undisputed that judges do have absolute immunity from civil lawsuits for money damages, but this is not a civil case. This is a criminal case, and her motion to dismiss should be denied. I recommend the court declines her invitation to dismiss on any other grounds, and she is presumed innocent, but that proving needs to happen at a jury trial. And so therefore, it is recommended that Dugan's motion to dismiss be denied. It's further ordered that amicus briefs can be filed. The motion for a supplemental jury questionnaire will be addressed by the main judge, Judge Adelman, later. This is by a magistrate judge. And your attention is directed to the rules of this court in Wisconsin, signed by Nancy Joseph, the U.S. magistrate judge. This will go up to the actual judge, but she's making the recommendation to him. There's plenty of case law here that says that Dugan should at least face the charges in court and that this immunity does not apply to her. So Dugan had a bad day today, wanted that case gone, and the lower level judge says no. Now, of course, the question is, what's going to happen with these illegals? And there was some talk about a work program and whether Trump is going to be deporting more people who commit crimes or what the plan is. Trump said there's no amnesty today, but we might have some other program coming down the pike. So here was the president.
There's no amnesty. What we're doing is we're getting rid of criminals, but we are doing a work program. Do you want to explain that, please?
Yeah, this morning we talked about protecting the farmers and the farmland, but obviously this president's vision of no amnesty, mass deportation continues, but in a strategic way, and then ensuring that our farmers have the labor that they need. Secretary Chavez DeRimmer has been a leader on this. Obviously this comes out of the Labor Department, but moving toward automation, ensuring that our farmers have that workforce and moving toward an American workforce. So all of the above.
We've got to give the farmers the people they need, but we're not talking amnesty.
No amnesty, says the president. And we had a little bit more here from Brooke Rollins, who I think you just heard as well. They were out today talking about this, and here's what she had to say.
I think I answered the second question, where we are on farm labor, a little bit earlier, but what I will say is that Lori Chavez DeRimmer is our Secretary of Labor, and the H-2A visa program, all of the programs that inure to moving in seasonal ag workers are under Secretary Chavez DeRimmer. She has been working around the clock with her team. I think we'll probably hear a little bit more about this today, and the conversations will continue, but I can't underscore enough. There will be no amnesty. The mass deportations continue, but in a strategic way, and we move the workforce towards automation and 100% American participation, which again, with 34 million people, able-bodied adults on Medicaid, we should be able to do that fairly quickly. Thank you.
All right, so that's what's happening in the immigration world. Backdoor Judge Dugan loses her motion to dismiss. No amnesty will be happening, even though we're going to have a smart approach to how we're dealing with workers. And the administration marches on. The prosecution will continue. We'll be here covering the backdoor judge. Thank you for subscribing and joining as we do.